Chief Justice, Lord Chief Justice, President, Judges, ladies and gentlemen, you're very welcome to the 6th Annual Distinguished Lecture hosted by the School of Law. The purpose of this event is to mark the end of the academic year, to bid farewell, hopefully not too tearfully, to our final year students and those who maybe have been final year students a few times, and to introduce our final years to graduates, which I think is a very good thing to do, and to kind of realise that you're now leaving to join a very important network. It's not just a network of Galway grads, but some of the more important ones are Galway grads, and I think it's a very good way to end the academic year. Tonight, the school is doubly honoured. We're doubly honoured by the presence of Chief Justice Denham and the Lord Chief Justice for Northern Ireland, Sir Declan Morgan. It's a really great occasion, I think, not just for the School of Law, but for the university, to have the two Chief Justices from the two jurisdictions on this island here on the one night. And it falls to me to introduce our distinguished chairperson, who will in turn then introduce our distinguished speaker. Ms. Justice Susan Denham became the 11th Chief Justice of Ireland in July 2011. In 1992, she was the first woman appointed to the Supreme Court. Her contribution to the modernisation of the administration of justice in Ireland has been enormous, and her work and indeed leadership was crucial in the establishment of the court service. She also played, I think, a pivotal role in making the case for the new Court of Appeal established last year, whose impact will probably be transformative on the administration of justice at a superior level in this country, but also perhaps on the evolution of the Supreme Court as a constitutional court. Chief Justice Denham is a member of the Royal Irish Academy. She was Pro-Chancellor of the University of Dublin from 1996 to 2010, and she has received honorary doctorates from Queen's, University of Ulster, DCU and UCD. Ladies and gentlemen, please welcome the Chief Justice of Ireland, Susan Denham.
Thank you. Thank you very much indeed. Lord Chief Justice, President, colleagues, ladies and gentlemen, it's a great pleasure to be here in Galway tonight, and I'm delighted to be chairing the School of Law Annual Distinguished Scholar Lecture for 2015. It's a very particular pleasure to introduce my friend, the Lord Chief Justice Declan Morgan. The Right Honourable Sir Declan Morgan, Lord Chief Justice of Northern Ireland, was born in Derry, educated at St Columb's College in Derry, Peterhouse in Cambridge and Queen's University in Belfast. He was called to the bar in Northern Ireland in 1976 and became a Queen's Counsel in 1993. He was Senior Crown Counsel for Northern Ireland from 2002 to 2004, and he was appointed a High Court judge in May 2004 and knighted. He also served for a time as Judge in Residence in Queen's, and Sir Declan was appointed Chairman of the Law Reform Advisory Committee for Northern Ireland in 2004. In 2007, he was appointed to the Family Division of the High Court in Belfast, and in September 2008, he became one of two judges responsible for judicial review, which is, of course, one of the huge growth areas in both our jurisdictions. He was Chairman of the Northern Ireland Law Commission from 2007 to 2009. And in 2009, he was sworn in as Lord Chief Justice. In February 2010, he was sworn in as a member of Her Majesty's Most Honourable Privy Council. And the Lord Chief Justice is also Chairman of Northern Ireland Judicial Appointments Commission. And he is an honorary bencher of Middle Temple. I think the two of us share this honour. So it gives me really great pleasure to call upon Lord Chief Justice Sir Declan Morgan to give the School of Law Annual Distinguished Lecture 2015 on the role of the judiciary in the vindication of human rights.
Chief Justice, President, ladies and gentlemen, can I first thank you, Chief Justice, for that kind introduction. It's a real pleasure to be with you this evening for me also, and I'd like to thank the members of the Law School for their kind invitation. I'm conscious of the impressive list of those who have given this prestigious lecture since Chris McCrudden, my good friend Chris McCrudden, gave the inaugural lecture some years ago. And I will try this evening to get close to the standard set by those speakers. Most of you will know that the work of judges these days involves all sorts of things apart from sitting in court, but sitting in court still is how many judges are evaluated. And one of the things that you find as a judge from sitting in court is that you realise that there is what I would call a healthy tension between the judge and the advocate. And it reminds me of a story that I was actually told by one of Susan's colleagues. He was presiding in court in a land dispute over land that wasn't really terribly valuable, and an awful lot of time and costs had been spent on it. But it was something that was considered of some importance so far as the members of the community were concerned. And counsel dealing with the appeal in relation to the issue said that this was a case in which there were really 3 points of law involved. One of them was a point which was, he said, decisive in favour of the appellant, and the other 2 were supportive, although not necessarily decisive. So he then opened the appeal and he introduced the points one by one. And after he'd finished dealing with them, he then went to sit down, and the chap who told me the story said, he said to him, just before you go, can you tell us which of these points you say was the point that is decisive in your favour? And counsel smiled and said, I'm sorry, I should have explained. That's the bit that you have to work out for yourself. That's what I mean about the tension. Recent events have demonstrated that the political, social and economic balance within modern European democracies can shift with alacrity. Such movements inevitably lead to a search for a new balance, or what I might call a point of equilibrium, around which a consensus can form. The principal purpose of this lecture is to demonstrate that in the United Kingdom, the incorporation of significant elements of the European Convention on Human Rights into domestic law has caused a change in the relationship between the 3 arms of government, the judiciary, the executive and the legislature. It has inevitably shifted the balance between us, and in this lecture I want to look in particular at 2 recent judgments of the United Kingdom Supreme Court, which in my view indicate where the balance now sits in our jurisdiction. This is not a new topic for me. I last addressed it in a lecture that I delivered in May 2012 in Blackhall Place, Dublin, which, as it happens, was also chaired kindly by the Chief Justice. I said then, and repeat now, that although it may be possible at any given time to identify the point of equilibrium, we live in a dynamic world, and balance is susceptible to alteration as a result of what Harold Macmillan used to call events. Judges in the higher courts clearly have a critical role to play in this exercise, but in carrying out the task of securing balance, we must all remember that our principal objective is to secure public confidence in the administration of justice. We are all committed to the rule of law. That means that the individual is protected from interference by the state other than in accordance with law. Secondly, the same law applies to everyone, regardless of their position in society. And thirdly, the content of laws must respect the fundamental principles of transparency and fairness. It also means that an independent judiciary is entitled to expect its position to be respected and secured by ministers and legislators, but must itself show proper respect for the role which others play in our justice system. A written constitution will normally guarantee the rights of the citizen and encourage the development of administrative law regimes to regulate any conflict between individual rights and the interests of the state. The United Kingdom judiciary did not have such a constitution to assist it and had to develop its jurisprudence in the field through the common law. The estimates of its past success vary. In a case called Bryn v Secretary of State, which was a case dealing with press freedom, in particular the broadcasting of material from Sinn Féin in the United Kingdom, Lord Ackner suggested that you would have to look long and hard before you could detect any difference between English common law and the principles set out in the Convention, at least in the eyes of, or through the eyes of, an English member of the judiciary. On the other hand, Conor Gearty, who may be known to some of you, in a recent blog decried the failure of the judiciary to protect the civil liberties of miners who were mistreated during the 1980 strikes and the treatment of those during the same period who protested in support of the campaign for nuclear disarmament. It is neither necessary for me nor, I think, profitable for you to try to resolve this difference of view, but I consider that there is considerable force in the observations of Keir Starmer QC writing in the recent Criminal Law Review. He suggested that whereas the common law traditionally secured protection from unwarranted interference with the exercise of freedoms, the importance of the Convention lay in promoting and securing positive rights which could be enforced by the citizen. It was against the backdrop of a developing administrative jurisprudence that the Human Rights Act domesticated many of the Convention rights in the United Kingdom in 1998. The method of implementation was important because it required the UK courts to take into account the Strasbourg jurisprudence when interpreting those rights. This has been interpreted as requiring UK courts to keep in step with the jurisprudence of the European Court of Human Rights. The European Court's approach to the interpretation of rights has itself been guided by the Vienna Convention on the Law of Treaties, but it has developed an evolutive interpretation based on the principle of effectiveness. It is a fundamental aspect of the European Court's approach that human rights treaties are a living instrument whose interpretation changes over time, and that the rights must be understood in the sense given to them by democratic societies today. At the heart of the Convention lies the concept of balance. The unqualified rights, such as the right to life, strike a balance between the individual and the state. The qualified rights require balance to be struck between the rights of different individuals and the interests of the public. The striking of that balance in the United Kingdom before the passing of the Act was largely a function of the executive, subject to what was called Wednesbury unreasonableness. Now, in many cases, it is for the courts to determine the proportionality of the decision, and in so doing, to determine what is necessary in a democratic society. And with that introduction, ladies and gentlemen, I now want to look at the approach of the United Kingdom Supreme Court in two recent cases involving absolutely fundamental areas. The first is the litigation surrounding the right to die, culminating in the case of Nicholson, in which judgment was given by the United Kingdom Supreme Court in June 2014. The background was that the appellants, NNL, appealed against a decision that English law relating to assisted suicide did not infringe the European Convention on Human Rights. In a related action, the appellant Director of Public Prosecutions appealed against an order requiring her to amend her policy on prosecutions in alleged assisted suicide cases. The three parties involved, L, N and M, each suffered from catastrophic physical disabilities, but their mental processes were unimpaired. They wished to die, but could not end their lives without a third party's assistance. The Suicide Act 1961, Section 2, imposed criminal liability on those who assisted suicide. The Court of Appeal rejected N and L's arguments for a declaration either that assisted suicide would be lawful or that the state of the law was incompatible with Article 8 of the Convention, which protects a person's private life and autonomy. It held in M's proceedings against the DPP for an order that he should clarify, or she should clarify her policy, that in certain respects the policy was not sufficiently clear in relation to healthcare professionals. The Supreme Court sat as a panel of 9 rather than 5. All agreed that a blanket ban on assisting suicide was not outside the margin of appreciation afforded to Convention states on that issue. Section 2 did not impose what the European Court of Rights would regard as an impermissible blanket ban on assisted suicide, which would take it outside the margin of appreciation. As the European Court had decided that it was for Convention states to decide whether their own law on assisted suicide infringed Article 8, the domestic courts, the Supreme Court said, had constitutional competence to decide whether Section 2 of the Suicide Act infringed Article 8. This is an important example of a principle which has been developed by the Supreme Court in the United Kingdom in a number of cases. The general approach to Convention cases for the first 10 years of the operation of the Act, when Lord Bingham was the presiding judge, was to ensure that human rights law in the United Kingdom kept in pace with Strasbourg but went no further. Since then, the Court has moved towards developing a domestic UK jurisprudence of rights asserted in the Convention, which on occasion has placed the UK ahead of Strasbourg. The majority then went on to conclude that it would not be institutionally inappropriate, or only appropriate if Parliament refused to address the issue, for a domestic court to consider whether Section 2 of the Suicide Act infringed the Convention. The Supreme Court concluded that the interference with Article 8 was grave, that is, the interference with autonomy. The arguments they concluded in favour of the current law were not overwhelming. The official attitude to assisted suicide seemed in practice to come close to tolerating it in certain circumstances. The instant appeal raised issues similar to those previously determined under the common law, such as the switching off of the life support machines. The rational connection between the aim of protecting abuse and the effect of Section 2 was fairly weak, and there was no compelling reason for the Court simply ceding jurisdiction to Parliament. Remember those words, simply ceding jurisdiction to Parliament. Provided the evidence and the arguments justified such a conclusion, the Court could properly hold that Section 2 infringed Article 8 and consider a declaration of incompatibility. In the event, 3 of the majority of 5 took the view that it would not be institutionally appropriate for the Court to draft a declaration at that time. Parliament should be given a last opportunity to consider amending Section 2 in light of the judgment. They were joined by 4 dissenters for whom Lord Sumption put the opposite argument, and he said, whether relaxing the absolute prohibition would involve unacceptable risks to vulnerable people should be decided by Parliament. The issue involved a choice between mutually inconsistent moral values about which there was no consensus. Such choices were legislative in nature. Parliament had made the relevant choice in enacting the 1961 Act. The parliamentary process was a better way of resolving issues involving controversial questions of fact arising from moral and social dilemmas. Those are thoughts that probably wouldn't even need to have been articulated 15 years beforehand. They now represented the minority view. There are plainly significant differences of approach between the justices in this case. The issue of the constitutional entitlement of the Court to determine the course of social policy in controversial areas raising moral and social dilemmas is fundamental. The majority of 5 concluded that this was an area in which they should not fear to tread. In support of that proposition, Lord Neuberger referred to the line of cases in which the courts have permitted the switching off of machines in relation to those in a permanent vegetative state, and the conjoined Quins case, where 1 child was saved. It is by no means clear, however, that the issue of the constitutional entitlement of the courts to strike the balance between individual rights and the state in this area is settled. The second question relates to the issue of competence. Public policy is generally the product of extensive consultation and research, whether by government departments or law reform bodies. The courts have before them only those matters upon which the parties rely. If it is not possible within the realistic limits of the management of court proceedings to involve those stakeholders who have an interest in the outcome of the policy, does the court have the competence to make the determination? Alternatively, is it for the state, which will invariably be a party to the proceedings, to ensure that any relevant matter is drawn to the attention of the court, which, as a matter of duty, must vindicate on the rights of the citizen? It is inevitable that from time to time the legislative and executive branches of government experience difficulty in dealing with these important moral and social issues. Increasingly, whether on the basis of constitutional rights in this jurisdiction or the Convention in our jurisdiction, those affected are utilising the courts as a mechanism to promote change. The difficulties that such litigation can raise were plainly evident in the recent judgments of the Supreme Court in this jurisdiction in the surrogacy case. But I do not want to say any more about that interesting case in this lecture. You have someone who's much better placed to do that, if you wish. The second case that I want to examine in a little depth is what I call the Lord Carlisle case, in which the United Kingdom Supreme Court gave judgment last November. In that case, the appellants were members of the House of Lords and House of Commons. They appealed against the refusal of their application for judicial review of the Secretary of State's decision to maintain a ban on R entering the United Kingdom. R was a dissident Iranian politician resident in Paris. She had been excluded from the United Kingdom since 1997 on the basis of her involvement with an Iranian organisation formerly described as a terrorist organisation. The appellants, who wanted R to address meetings in Westminster about policy issues relating to Iran, asked the Secretary of State to lift the exclusion. After taking the advice of the Foreign Office, the Secretary of State refused. She considered that Iran would see any lifting of the exclusion as a political move against it and would be likely to engage in reprisals that would put British interests and British nationals at risk. The appellants sought judicial review, claiming that the decision violated their right to freedom of expression guaranteed by Article 10 of the Convention. Their application was refused by the Divisional Court and their appeal was dismissed by the Court of Appeal. Before the Supreme Court, it was common ground that R's exclusion amounted to an interference with Article 10. The issues were whether 1. The Secretary of State had been entitled to take into account of the potential reaction of a foreign state which had no respect for freedom of speech, and secondly, whether the interference was justified as a proportionate response to that predicted threat. The appeal was dismissed. The court said that in determining whether a person's presence in the United Kingdom was conducive to the public good, the potential consequences of that person's admission had to be considered. The existence and gravity of a threat to British nationals or interests were questions of fact and were not any less relevant because the threat emanated from a state that did not share British values. If, in order to protect the democratic values of British society from the repressive actions of a regime which did not share those values, it was necessary to interfere with a convention right, then such interference was justified. When considering decisions of the executive, the court said that they would traditionally not usurp the function of the decision maker. However, the Human Rights Act made justiciable any arguable allegation that a person's convention rights had been infringed. Thus, when it came to reviewing the compatibility of executive decisions with the convention, there was no constitutional bar to any inquiry that was relevant and necessary to enable the court to adjudicate. The court was not entitled to substitute its own view for that of the decision maker, and the degree and quality of the judicial scrutiny called for would depend on the significance of the right. the degree of interference, and the factors capable of justifying the interference. The court had to test the adequacy of the factual basis of the decision, consider whether the objective was necessary, review the rationality of the supposed connection between the objective and the means, and it then had to consider whether some less onerous alternative would have been available without unreasonably impairing the objective. The court was the ultimate arbiter of the appropriate balance between the convention rights engaged and the interests of the community relied upon to justify interfering with it. And remember, this is in the context of national security, that the court is the ultimate arbiter. However, the court would not remake a decision reasonably open to the decision maker, and it would not make a judgment about the relative advantages and disadvantages of the course selected or of the pure policy choices. On those matters, in determining what weight to give to the evidence, the court was entitled to attach special weight to the judgment of a decision maker with special institutional competence. If ours admission to the United Kingdom would pose an appreciable risk of reprisals, as claimed by the Secretary of State, then the interference was clearly justified in the interests of national security, public safety, and the protection of the rights of others. Article 10 rights were qualified rights, and there had been no challenge in that case either to the facts or as to the Secretary of State's bona fides. In those circumstances, the court could only quash her decision if she had underestimated the importance of freedom of speech, if the Foreign Office had overstated the risks, or if her objective could reasonably have been achieved by some lesser measure. None of those factors applied. The court decided the Secretary of State had not underestimated the importance of freedom of expression, or had not been denied the right to express her views. She could have given her talk by video link, and therefore the appellants had not been denied the right to receive them. Nor had the Foreign Office advice overstated the risks. Its assessment was supported by subsequent events. In any event, making predictions of that kind called for an experienced judgment, and the consequences of getting it wrong were sufficiently serious to warrant a precautionary approach. Seeking the advice of the Foreign Office had been the only reasonable course open to the Secretary of State, and it was difficult to see how she could rationally have rejected the advice she was given, nor would the Supreme Court reject the advice, since to do so would be to step beyond the proper function of a court of review. And finally, it was difficult to see what lesser measure would have sufficed. I now want to examine what these cases tell us and why they are important. What in particular do they tell us about the development of what I call a constitutional jurisprudence in the United Kingdom? The first and most obvious point is that neither of these cases would have been entertained by the House of Lords 15 years ago. If they had been instituted, they would have been dismissed at first instance on the basis that such issues were outside the constitutional function and competence of the courts. That in itself is a dramatic indicator of the way in which the balance between the courts and the other arms of government has shifted since the domestication of the Convention rights in the United Kingdom. There are similarities between the cases. Both are cases involving allegations of an interference with qualified rights. In Nicklinson, the interference was a threat of prosecution, but it might also have been characterised as a case in which the court was asked to assert from the right to private life and autonomy a positive right to engage others in order to vindicate the exercise of the right to die at a time and in circumstances of one's own choosing. In both cases, the ultimate issue for the court was the outworking of the proportionality test. The nature of this test has been the subject of review and revision since the introduction of the Human Rights Act, but it is now clear that there is an established four-point test set out by Lord Reid in the Bankmellet case decided earlier in 2014, where he said the question depends on an exacting analysis of the factual case advanced in defence of the measure in order to determine first whether its objective is sufficiently important to justify the limitation of a fundamental right. Second, whether it is rationally connected to the objective. Third, whether a less intrusive measure could have been used. And fourthly, whether, having regard to these matters and to the severity of the consequences, a fair balance has been struck between the rights of the individual and the interests of the community. He said these four requirements are logically separate, but in practice they inevitably overlap because the same facts are likely to be relevant to more than one of them. What I think is clear is that this is intended to be a flexible standard, but if applied with full rigour, a demanding standard. The flexibility is hardly surprising in setting principles in an area such as this. Turning then to the role of the court, the effect of the 1998 Act is that any interference at all with a convention, with a right protected by the convention, will engage the involvement of the court. Since the convention is a living instrument, that means that the nature and content of the rights protected will vary, and that, it seems to me, has consequences both for legislatures and policymakers, as I will discuss further. Where there is such interference, the balance between the interests of the citizen and the public interest will be determined by the court, not by the legislature, but by the court, using the proportionality test. The starting point is that the court will subject to searching analysis the factual circumstances, the extent of the interference, the objective which the interference seeks to protect, and the extent to which the interference protects those objectives, and whether the protection of state interests is sufficiently important to interfere with the right, and whether a proper balance has been struck, bearing in mind any less intrusive way of protecting the public interest. In carrying out this task, the court will scrutinise the evidence, but will recognise the evidential weight that should be accorded to decision makers with special institutional competence. I suspect that there will be some interesting claims to fall into that category, but it may be that rather than identify the characteristics of such a beast, the courts will adopt the elephant test. You will know one when you see it. Despite the intensity of review, these authorities make clear that executive decision-making is constitutionally for the executive, not for the courts. The court's function has been and remains one of review, albeit at a particularly intense level. But one can immediately see the difficulties facing policymakers in cases where convention rights are involved. Not alone must prospective decisions be convention-proofed, as Nicholson demonstrates, it is also necessary to review past decisions which have continuing consequences to ensure that they are not at risk of failing the proportionality test in this dynamic legal world. The balance that is struck between the arms of government will vary from jurisdiction to jurisdiction, depending inter alia on the constitutional structures, political background, community and social history, and place in the world. In this lecture, I have sought to record the manner in which the relationship between the courts and the other arms of government has changed dramatically over the course of the last 15 years in the United Kingdom. The United Kingdom's largely unwritten constitution has the advantage of allowing the structures to respond to a changing world on a pragmatic basis. That is a rather different model from that in jurisdictions with written constitutions, where such changes require consideration and approval from the public. I do not suggest, therefore, that there is a direct read across between the way in which we have now developed a constitutional jurisprudence and the approach taken in this or indeed other jurisdictions. But I hope that you have found it interesting to review this small aspect of our dynamic legal development. Thank you very much.
the Lord Chief Justice has discussed some very important issues in relation to the judiciary and the vindication of human rights in the United Kingdom as it moves from a parliamentary sovereignty into a situation where, with the introduction of the European Convention into their domestic law, their Supreme Court takes on a whole new role. I understand that there's going to be some roving mics and that we have time for some questions. Now, we have some time for questions, and we have a very interesting topic thrown at us from a jurisdiction which has taken huge changes in the last 15 years as it moves towards a country where the European Convention is part of the domestic law, and so the judiciary are grappling with questions that they didn't previously when it was pure parliamentary sovereignty. Have we got questions? We have a roving mic. Or suggestions from anybody?
Good evening. Thank you, Lord Chief Justice, for such a stimulating talk. My name is Dr. Brian Tobin from the School of Law. I'd just like to ask your opinion on the two approaches to the European Convention on Human Rights in the United Kingdom. There is, I suppose, the ULA and special adjudicator approach that the UK courts should follow the European Court of Human Rights interpretations of convention rights, no more, but certainly no less. Then there was an approach in the case of Ray P., where the UK House of Lords still was at the time, decided that where the European Court of Human Rights has not yet been called on to adjudicate on a certain issue, in that case it was the rights of unmarried adopters under Article 8, that the UK courts could actually adopt their own interpretation because the court would have declined to adopt an interpretation by maybe having recourse to the margin of appreciation. Personally, I find that case to be something of a stretch because to date the European Court of Human Rights has not been called on to decide on the rights of unmarried adopters, and I really feel the UK House of Lords went too far there. But then they seem to pull back a little bit in the Ambrose case, I think, from a few years back, where the two approaches were very much to the fore, and there was a difference in opinion as to whether ULA should be favoured or I suppose, the more elastic Ray P approach. And I'd just be curious to know which approach you would prefer or think is more sound.
I think the starting point of the answer is I'm not there, and therefore I have no influence on the approach that they're going to take. But I do think you raise an interesting issue. There's no doubt that while Lord Bingham was the senior law lord, that his view about the Human Rights Act was about ensuring that it was bedded down in an orderly fashion. And an orderly fashion meant that the international rights were being domesticated. That, if you like, was the jurisprudential base upon which human rights claims were approached. Ray P was one of the cases that was a stretch, and there were, I think, two others at least in which the court went beyond that. But I do think that the arguments that held sway in Nicholson about the entitlement of the court to take its own view within the margin of appreciation is a forerunner of a different approach, and that approach is towards the development by the Supreme Court of a British interpretation to human rights. So, for instance, we have the Horncastle case, which was a case about hearsay, where the European Court of Human Rights had previously, by way of a Grand Chamber, said, well, you can't base a conviction on hearsay. The Supreme Court took a different view, set out its arguments, and as it happens, the European Court of Human Rights in a subsequent decision backed off somewhat and accepted the UK position. But what I think cases like Nicholson are telling you is that the Supreme Court is moving potentially towards looking at a British interpretation of what human rights mean. And might there be a driver for that? Well, I suppose there are some, and of course I wouldn't be one of them, who would suggest that they're looking over their shoulders at the government deciding to withdraw from the European Convention on Human Rights, because at that stage any subsequent replacement would be a British Bill of Human Rights or something of that kind. And it's not altogether impossible that some at least are at least subconsciously thinking to themselves, maybe we should start developing British standards in relation to human rights now, so that they become embedded in the event that that might occur. And a case that might go the other way in those circumstances is the prisoner voting case, whereas, you know, the European Court of Human Rights has taken the view that a blanket ban is inappropriate, but at the moment there appears to be no prospect whatsoever of securing a parliamentary majority for even the most relaxed ban, for instance, allowing those with sentences of 12 months or less to vote.
Yes, would you like to pick that up? I mean, it's so fascinating to watch this development in British jurisprudence. When the Human Rights Act was coming in, I had some conversations with members of the superior courts in the United Kingdom, and they were coming to us saying, you have had your constitutional court since 1937. How do you get this balance? How do you find it? Because, of course, we've got to remember that in 1937, our constitution was absolutely prescient in two relevant ways here. First, by the introduction of the human rights, which, when you think about Europe in the 1930s, think about Nazis in Germany, fascism all over the continent, and here were we, a little island off an island, introducing this amazing human rights in our constitution. And then the second extraordinary thing and innovative thing that was introduced was the review given to the superior courts of legislation and rights. So that, and this was the first time in the common law world, because although the Constitutional Supreme Court of the United States has that power to review other institutions and to determine what is constitutional and not, that was found by the Supreme Court. It isn't written in their constitution. And so when you think of our drafters in the 1930s looking at our constitution, this was clearly an idea that came from the United States, but it was written into the constitution. And when it was written in, they understood what they were doing. So it was an extraordinary move, my little nation, in the 1930s to do this. And since especially the 1960s, we have, of course, developed our constitutional jurisprudence in relation to these issues. So it was very interesting in 15 years ago talking to colleagues in London about how they were going to do it. And to hear Lord Chief Justice tonight saying Lord Bingham took this approach, but now we have a new approach where clearly the court is looking at a jurisprudence, a constitutional jurisprudence, for whatever reason, in the United Kingdom, and to see that balance coming, because moving from parliamentary sovereignty into this balance of power is an amazing step. So it really, you're bringing us right up to speed in relation to extraordinary developments in the United Kingdom. Have we got another question or suggestion? Anybody wish to add anything in relation to, yes?
Lord Chief Justice, you're very welcome. Derek Nolan is my name. I'm a graduate of the School of Law and a member of Parliament for the area, so one of the legislators. Can I ask you a question about the attitudes of the judiciary? You mentioned the 15 years. It's a kind of a constitutional landmark. It's huge. You read, from a political point of view, in the papers in the UK, constant backlash against human rights. Do you think that there is any kind of a reluctance, or on the part of the judiciary, to push the human rights agenda or are they reacting somewhat to the political sphere, to the public domain, in order to maintain it and develop it slowly rather than more radically?
Again, an interesting question. And it raises this question of, are 11 fairly old white men and one woman the people who
Lonely
should be...
woman, yes.
Are they the people who should be developing the balance in relation to these important moral and social issues within a country like the United Kingdom, having been appointed without any democratic process or involvement whatsoever? That's part of the debate, and it seems to me that part of what is likely to happen is that there will be an increasing scrutiny of who it is actually sits on the Supreme Court making these decisions, and what, if any, involvement the executive stroke legislature should have in examining the approaches or views of those who sit. So I see within there issues for the future which are beginning to boil now and likely to arise. In terms of your question about whether or not people are operating on a softly approach rather than, as it were, feeling free to expound their views, when you get to the Supreme Court level, the decisions that you're making are not the same as the decisions you make in a court of appeal. In a court of appeal, largely, you spend your time working out whether on the authorities and looking at the background and applying the principles, somebody has got the right answer. And usually there is a right answer and a wrong answer. In the Supreme Court, it's different. Virtually every question that you ask in the Supreme Court could be decided either way, in the sense that there is a respectable argument that could be put one way or the other for each view. Take Nicholson as an example. It's perfectly clear that there's a respectable argument for the view that personal autonomy, which allows people to make their own decisions about the time and circumstances of their death, should be respected. There's also a perfectly, and that the court should vindicate that right. And there's also a perfectly respectable view that says that decisions of that type are so fundamental in relation to societies that they're decisions that should be made by people who are directly accountable to those in respect of whom the decisions are made, particularly where the risk that one is guarding against is the risk that people will feel pressure to commit suicide and thereby release funds or whatever it may be for their offspring. And for what it's worth, I have listened carefully to the Court of Protection judge in London, a judge called Judith Parker, who tells me, don't make any mistake about it. There are such cases. They come in at the moment to have the machines cut off because there are collateral issues that they want to deal with. So I think the answer to your question is that the judges who are making these decisions are influenced by their own thinking about what should happen. But they also, I think, recognise that they are making decisions which are not just their decisions, they're decisions about what is right for the community. And in making those sorts of decisions in social and moral matters, it seems to me that inevitably they are taking on board their view of what the community actually wants. And in many instances, it's that will operate as a brake, whether to expand or not to involve themselves in the development of human rights.
Thank you very much indeed. Have we another suggestion or question in relation to... Yes?
Michael O'Hara, graduate of the School of Law and barrister of the Western Circuit. First of all, I'd like to thank the Lord Chief Justice for coming to Galway, and to thank him as well for those of us who went up from Galway and went up from the Republic 2.5 years ago to be called to the Bar of Northern Ireland, and he made us feel extremely welcome indeed, and made us, on my first visit to Belfast, certainly made me feel very much at home. So thanks for that. And just in relation to, I suppose, both Chief Justices, maybe more aimed at our own jurisdiction, I suppose an observation that there's a feeling out there that, particularly with the recent decision on unconstitutionally obtained evidence and the illegally obtained evidence case that was decided recently, I suppose there's a fear that, particularly with courts like the Commercial Court, that here in the west of Ireland and probably around the country, that we're dependent on the courts to stand up for the citizen. And certainly as a student in what was then UCG in the 1980s and 90s, you looked to the courts as a counterbalance to the country and to the legislature and to the government, and your hope was the courts. And I suppose just a fear that hope is being dashed, and that I think ordinary people out here in the country, look to the courts, look to the Supreme Court, and probably no different in Northern Ireland, that they look to the superior courts there to uphold the rights of the ordinary citizens. And a fear of institutions like NAMA, and in particular the Commercial Court, giving NAMA what they want all of the time, giving the banks what they want, a fear of simple rubber stamping exercise when you go into the commercial court as an advocate, that you haven't a hope, basically, and that you have to fight tooth and nail for the small person as an advocate. And I know this is probably very general, but just the hope is still there that our Supreme Court will stand up for the small person and for the small citizen outside the pale. And just observations on that.
I think, yes. Well, I think that that's a question really posed towards me. The duty of the Supreme Court is to uphold the Constitution, which is voted by the people. It's the people's document, and the people alone change it. And at the core of our Constitution is the rights we've been discussing and referring to, and the common good. And it's the core responsibility of the Supreme Court to find the harmonious balance between an individual's rights and the common good. And in most of these cases, that is where we are trying to find a balance. But I think throughout our jurisprudence, we are very human rights and individually identified. And that you refer to a recent decision, which is a very minor shift in the law in relation to the admission of evidence, and is entirely in keeping with the common law jurisdictions of the world, and in fact is more individual advantaged than in other jurisdictions. It's a tiny development, more in keeping with jurisprudence of about 30 years ago than 20 years ago. So you can be absolutely assured that the Supreme Court takes very seriously its responsibility to protect the individual rights. Yes?
Norni Lajanov, graduate of NUI Galway. Given the emphasis you put on how important the European Convention of Human Rights was for emboldening the UK Supreme Court and its approach to human rights, does it concern you about the prospect that the UK may no longer be a contracting party to the CHR, and that this might somehow be it might somehow lead to a chilling effect on the judiciary?
I think you used an interesting form of words. You asked whether or not the Supreme Court had been emboldened by the domestication of the Human Rights Act or the Human Rights Convention into domestic law. I mean, you could have said, how did the Supreme Court react to their obligation to apply the Human Rights Convention as a matter of domestic law, because that, in fact, is what happened. But your choice of words was right. The Supreme Court has been emboldened, and emboldened people are generally slow to change their minds, is my view. And I suspect that no matter what happens in relation to the Convention, and there are so many difficulties involved in the United Kingdom withdrawing from the Convention that it is really very difficult to see how it could happen. The first of which is that unless there was a single-party government of a particular persuasion, the issue will not even be up for discussion because there's no coalition partner who would tolerate it. But my own view is that the last 15 years has seen such a major shift in development in the accountability of the executive to the courts and through that to the public that I would be astonished if there was a significant change in that general thesis.
Thank you very much for that question. Do we have another question? Or another, anybody wants to raise anything? We might bring that to. Okay. Do we have anybody else here? Well, I think that we bring this part of the evening to a conclusion. We're very indebted to Lord Chief Justice Morgan for his insights on the role of the judiciary in the vindication of human rights, and it's most interesting to us to hear him talk about the changes and the shifts in the United Kingdom, and so that we can draw comparators with the situation here in Ireland. Lord Chief Justice has spoken on many occasions on judicial independence and the important part it plays in upholding the rule of law in a free and democratic society. He has, of course, pointed out that the primary function of the judiciary is the fair and impartial resolution of disputes between individuals and between individuals and the state in accordance with law. No other organ of the state carries out this function. It's evident, therefore, that in order to carry out the function, the independence of each judge is critical. It can properly be described as the precondition for the ability to carry out this responsibility. And he's noted that the independence of the judiciary is not only important in upholding the rights of the individual, but to strike a balance between the rights and the freedoms of the individual and the protections of the rights and freedoms of the community. And that's what we've been really looking at today, this balance between the individual rights and the community. It's, of course, therefore critical that each judge is independent of each other and of the government. The Lord Chief Justice has illustrated again the importance of the independence of the judiciary in his lecture this evening, where he has analysed fundamental principles in the relationship between the judiciary and human rights, and in the three great organs of government, the legislature and the executive and the judiciary, and the shifting balance of power between these in the United Kingdom at the moment. So we are very grateful indeed for him for bringing this very interesting topic and contemplation to us this evening. Thank you very much indeed. I will now hand over to Professor Darko O'Connell.
Ladies and gentlemen, I think that was a really brilliant lecture.
Absolutely.
I was looking at my European human rights students, and if you're wondering whether it's relevant to the exam, it is relevant to the exam. I think it's actually relevant to every exam that any law student would do. It's a model of pure reason, brilliant lawyerliness, and I think great subtlety. I'm looking forward to reading the text of the lecture in greater detail, because I think it was extremely rich indeed, and I'm extremely grateful to Lord Chief Justice Morgan for maintaining, I think, a tradition of excellence in this annual Distinguished Lecture Series. I know he was worried about his predecessors. This was the 6th lecture. It was the 6th excellent lecture, and I think that was very clear. In reflecting on the issues of separation of powers and adjusting, and some of this is an insight that I think I have from the Law Reform Commission, is that we have to get comfortable with the idea of living in a deliberative democracy. That it isn't about one branch winning all the time and another branch losing, but in the deliberative democracy where things are dynamic, as the Lord Chief Justice said, I think we can find ways, very creative ways, very modern ways of doing good things, doing proper things, without being overly concerned about the democratic propriety of those things if we change our view of what democracy is. And I think that's something that possibly is worth reflecting on. So a few thank yous, and then we have a presentation to make, a very, very special presentation to make at the end of this event. Firstly, just in case you're wondering, we are having a reception in the staff club, which is diagonally across the quadrangle. This is the real goodbye, the tearful part for our students. It is a great credit to you that you have turned up in such numbers. 48 hours before the commencement of your exams. I think that's a sign of great confidence as well. And I'm sure your confidence will increase with the wine that you'll have later tonight. Just, I would say one thing, that the insights that you do have tonight, hold those thoughts, because you will definitely not remember them tomorrow, or indeed on Monday when you need to remember them. But it's, everything in moderation, so have a nice celebration afterwards. I'm very grateful to the President, Jim Brown, for supporting this event again, and Catherine McGuinness, the chair of Údarás na Hallscoile. Both Jim and Catherine deserve frequent flyer bonus points for coming to law events, because they're at every law event that we have, and it's great to have that support in the school. It's great for you, I think, as students to see that. And of course, Catherine is a particularly close friend of the School of Law. She's a person with a wonderful tradition as a judge, but not just as a judge, as you see from the Irish Times this week, as an activist as well, and a very bold activist and at times. And it's great that you can be with us here again tonight. I hope I haven't embarrassed you. It's also great to see so many graduates here. Looking around the room, there's an awful lot of graduates. We were doing a lot in the last couple of years to communicate with our graduate community. There's one graduate in particular that I spot, and this is to exercise a privilege, I suppose, of the head of school. It's a classmate of mine, Deirdre Fottrell, who's here tonight. And Deirdre has become a QC in the last few months. And I'm delighted that she's back here with her mother tonight at this event. She's somebody who's worth buttonholing at the reception afterwards, and she'll tell you how it's done in London. But she's done extremely well, and those of us who were here in the 1980s, which is a long time ago, I know, we're extremely proud of Deirdre and what she has achieved. Now to the final part of the evening. One of our former colleagues, in fact, I'm just thinking a lot of the students here won't have been taught by him, but one of our former colleagues, Francis Comerford, became a judge in the last couple of months. And Francis lectured for many years in the School of Law. He lectured on Saturday mornings. I did contract with Francis on Saturday mornings. That was before I developed a consciousness of Article 3 of the European Convention of Human Rights, which was, I'm sure, difficult for him as it was for us. His parents worked in this university as well. I'm delighted that his mother, Phil Comerford, is here tonight. Phil was the most student-centred person in the university before the phrase student-centred was invented. She was on the Student Services Committee, College Union, and all of these kind of committees in the past. And some of us as students served on those committees with her. And Francis is a very brilliant lawyer. He has a fantastically inquiring mind, but I think more importantly, and will be remembered for this, he was an extremely kind teacher. An extremely kind teacher, very benevolent. I don't think I ever saw him at an exam board arguing to take a mark down. He was always, even in relation to his own marks, he was very generous. And as a barrister, he was highly regarded as a most collegial person. The things that have been said about him since he became a judge would be embarrassing to repeat, but they're universally positive, and he's a truly and a very worthy, popular person, and I think he will make a wonderful judge of the Supreme Court, a very kind and empathic judge. Sorry, of the Circuit Court. We'll take it in stages. I hope if I ever have difficulty that I do actually come up in front of Judge Comerford. So. If he wouldn't mind, we want to make a small presentation. The Chief Justice is going to make a small presentation to Francis, and if you could just congratulate him on his elevation to the bench.
Congratulations, Francis. Well done.
So we just gave Francis one of my etchings framed. So now everybody can go to the reception, which we have some music and food and wine at the reception, which is just diagonally across the quad. And please do stay around to meet our speakers. And thanks also very much to the Chief Justice, who did, I think, a wonderful job chairing this occasion as well.